So thank you for having me. I'm going to be talking about contract must-haves, and this is really written specifically to address the residential requirements, but I'm happy to talk about commercial. There are some differences. Mostly it is payment terms, exclusions, and warranties. So if at any time you have a question and it relates to commercial, or you just have a question, I am happy to be interrupted. I like that. I get tired of just listening to myself talk, so a little interaction is great and appreciated. So let's get started. So who am I? I'm a board-certified construction lawyer. I've been a lawyer for almost 20 years now, and I've been part of NTRCA and RCAT for, I don't know, maybe 12 years. I think I started about the same time Sarah did, and so that's what I used to sort of date myself. Anyway, I talk a lot anyway, but I talk a lot about things related to construction and storm restoration. When I first got involved, I did not know how different it was from regular commercial construction. It is very different for any of you who do both. So I had a big learning curve. I think I'm more or less up to speed, but I'm always open to any information anybody wants to share with me. So that's me. This is my disclaimer. I am not offering legal advice. This is an educational presentation, and before you implement anything I say, you should check with your attorney and make sure that it is proper for your business. If you are my client, please do what I ask you to do. Okay, so here are the things we're going to cover. And what I love about doing this Elevate is I have enough time to actually slow down and talk about the stuff we're going to talk about. Because normally I have to do this in about 40 minutes. And I'm from California, so I can talk pretty fast. But I like to just take my time and be able to answer questions. So this is all the stuff we're going to talk about and some more. But this is what every storm restoration contract should have. If anybody wants a copy of the presentation electronically, I'm happy to share it. Just reach out and let me know. You can take pictures if you'd like. You can make notes on the handout. Does everyone have a handout, by the way? Okay. But if you want it electronically to share with people, and I'm happy for you to share this with anybody you want to. I'm not trying to hide the ball. I want this information out there. So feel free to share. Feel free to ask me for copies. Okay, so let's start with something that I learned a couple years ago that I didn't know, that if you want to file a lien on a homestead, your contract has to have your address on it. And I'm seeing more and more contracts without an address, and I have my thoughts about some of the reasons why that is. Some folks, maybe they work from home, they don't want to have their home address, and I agree with that. Other folks have multiple locations, and you don't really know which location to put on because you don't want to limit yourself, and I understand that. But it is good to have an address on your contract, especially if you want to advertise yourself as someone who's local. So it's required if you want to foreclose on a homestead. I do believe it's more professional looking. And if you work from home, there are virtual offices. You pay, I don't know, $300 or $400 a month. You can have a virtual office at an executive suite. And then you have a place to meet somebody if you can't meet them in their home or somewhere else. So, and I do not believe that a post office mail drop would qualify for a physical address. So the first thing is physical address. Payment terms. And I don't know why I see a lot of contracts with no payment terms. So we're going to talk about contingency contracts and what makes them enforceable. And one of them is, well, we'll talk about that anyway. So there's two kinds of payment terms, right? There's a lump sum, and then there's what's called the contingency, which really in my practice is what I see a lot more contractors using is the contingency contract. And whichever one you want to use, neither one is good or bad. It's, whatever your business model is, that's what you should be using. If you're going to use a lump sum contract, here are the things that you need to make sure you're especially paying attention to. It excludes or it includes tax. You just need to know, right? You need to know what you're paying tax on, and you need to know whether you're including it or excluding it personally. think if you're going to have a lump sum contract, it ought to include tax. Otherwise, it's not really a true lump sum. It should have be for defined scopes only. So at the point where you're comfortable doing a lump sum, there should be a defined scope that goes with it, and it should be pretty specific. So saying roof and gutters is not specific enough for a lump sum contract. Owner upgrades, change orders, they're either included or they're excluded. And a lot of times what I see is I'll see somebody, as alternatives typically. And this is really more probably common in commercial than residential, but you just need to, the more specific you can be, the better off you are. And exclusions are as important in a contract as inclusions. And that's just something that a lot of folks don't necessarily think about. So you want to certainly be excluding any hidden conditions. You want to be excluding anything that you're not doing. So if you're not doing a complete 100% soup to nuts, you need to make sure that you're clear about that. Whether or not supplements are included, and really you can include a supplement that's been approved, but you can't include a supplement that's not yet been submitted. And you need to be sure that your lump sum contract says that. And then price increases. And I don't know, I have different people telling me that they are or are not still experiencing price increases. And so if that's something you have a concern about, you need to address it in the contract. Because if it's not in the contract, it never happened. That's the world we live in now. So for contingency, it needs to be RCV value of the contract, not proceeds. That's two entirely different things. A proceeds contract is a much smaller number than an RCV contract. So you need to make sure, if you're going to take anything away, there's 3 or 4 really important things, and that's one of them, RCV value of the claim. Owner deductible has to be paid. How are you going to handle supplements? Recoverable and non-recoverable depreciation needs to be addressed. Owner upgrades, code compliance, GCO&P, and then timing of payment. So all of those things need to be addressed specifically in a contingency contract. And I like it on the front page because I don't want, that's not the kind of thing you want to hide the ball. Lump sum addendum. So most of my clients sell contingency contracts because you don't really know what the scope's going to be. It's much harder to sell a contract to a homeowner specifically, and a lot of commercial people too. I'm having a big hairy fight with somebody right now over this issue, but it's much harder to sell a lump sum contract if you're not selling value. And so what you want to do as soon as you have your contingency contract, you've got your scope and your price defined, you want to turn that contingency contract into a lump sum. Because there's a lot less arguing later on after the work is done about how much needs to be paid. Because you have an addendum now that says this is the defined scope and this is the defined price. So it takes out uncertainty and hazy scopes. Because it's an addendum, it does not replace the contract. So it's not a new contract, it's an addition to the existing contract. And by using an addendum rather than a new contract, you avoid the appearance from the owner's side that they can say yes or no to this new contract and just cancel, because that we don't want. So it needs to be signed and acknowledged by the property owner. And here's a couple of options. So this is a traditional addendum. Basically at the top it's, owner, date, address, and then it has the defined addenda in the middle of it with the price, and then it says specifically that this doesn't change the contract and all the same contract terms still apply, and sign below. So this is one way to do it. Here's another way that I see clients do this sometimes when especially if they're working off of an Xactimate. So you leave the unit prices, you leave the unit quantity, you take out the pricing. And then at the bottom, really rather than, this is so cool. So rather than all this foolishness right here, I would really just have a total contract. Yes, ma'am.
Instead of having your Xactimate print out in this format, you can just choose a different report type in Xactimate, and it will do all that for you, so you don't have to go out and pick out pricing line by line.
Right, and so if you're an Xactimate, if you're someone who knows how to use Xactimate properly, you can generate a report that provides all this information, and then just at the bottom there's a total. So I'm honestly, breaking out overhead and profit and all that just seems to lead to confusion, and so I'm a big fan of simple, and so I like just having a price at the bottom. So this is just another option, and depending on the sophistication of your office staff, here's another way to do it.
What's your reasoning for doing a lump sum versus a line itemized dollar value?
Sure. So the reason why I like a lump sum, the main reason why there's two reasons. One is because it's simpler for the insured to understand. It's just a number. Here's all the things I'm going to do, and here's a number. The other reason why I like it is because insurance companies want to go into your Xactimate and pick it apart line item by line item. And when you have a lump sum, then they can't do that. It is simply a listed scope of work and a dollar value at the end. And it saves, some of the shenanigans that the adjusters get up to when they try to say, well, that line item's too high, and you've got way too much profit in there, and you shouldn't get your profit down below because you have profit up above. So it helps avoid those arguments.
Okay.
Yeah. So one of about 6 or 7 years ago maybe, I had a client who had a contingency contract that was signed, and the insurance company wouldn't approve a appropriate scope and price, and so it went to, I don't remember if it went to a PA, if it went to an attorney, but it went into litigation, pre-litigation, and it came back and it was just a number. So the insurance company said, fine, for this loss, I'm going to pay you X. And there was no defined scope, and there was no unit pricing. And the insured said, well, guess what, contractor? We don't have a contract because insurance didn't approve a scope. And unfortunately, I think the way that contract was written, that was the right, thank God it wasn't my contract, but I think that was going to be very much of an uphill battle. And so to address that issue, that's why my contracts get longer or the bond gets smaller, because every time something happens, I have to address it in the contract, right? So I'm telling you that to tell you that it does happen, and if you're relying on the insurance company issuing a scope in order to have an enforceable contract, you are leaving yourself vulnerable. So this is an option for defining scope and price that I have included in all of my contracts. And basically it says, at the time of payment, if there's no defined scope, then the contractor is going to make sure there's a defined scope. So instead of leaving it in the hands of the insurance company, what this basically says is it's going to be the maximum scope of repairs developed by the contractor or others. So if there's a PA involved, the PA might do it, right? But if not, you as the contractor need to make sure there is a scope of work on the table, and that it is what you want it to be to do the work that needs to be done. So this will save the contract from being unenforceable for lack of scope. Does that make sense? Yeah. So another alternative to contingency contracts, and I actually have co-written a package of contract documents called Contractor Pro Docs. It's a good package. It's like, 36 or 40 or something different documents that all together is a great package for a contractor, either who's starting out or just isn't confident that they have a good solid package of documents. Most of the time when someone says, hey Karen, can you look at my contract? I got it from a buddy, or I cobbled it together from a bunch of stuff I found on the internet, right? So The difference between that package and just a typical contingency contract is it's kind of an A-B. So it's a service agreement that basically says, I'm going to, for free, develop your scope. I'm going to submit it to insurance. I'm going to defend it, etc. And when the insurance company accepts the claim, then you're going to sign a construction agreement with me that has a defined scope. So that's really the difference. I know a lot of contractors who use that kind of A-B thing, and they really like it. And certainly a service agreement is a good way to keep an insured from feeling like they're signing up for too much. If they're just not ready to sign a construction contract, they might be willing to sign a service agreement so that they're not obligated. If insurance doesn't approve a scope, they're not obligated anyway, but they don't understand that, and that helps, right? So one alternative is a service agreement followed by a construction contract, and that construction contract would be a lump sum at that point. So, all right, so that's kind of the basic nuts and bolts of the contract and how you have an enforceable contract formed. So let's talk about the gotta have it stuff. And some of this stuff is related to residential, so if you're not doing residential, or if you do both, we'll talk about that. But this is the gotta have it stuff. Okay, so everybody has to have the payment of deductibles, statutory language in their contract. And I still see contracts without it. I see contracts where it's in tiny 8-point font on the back of the page, etc. So the law requires a minimum 10-point bold font. 12-point bold font. So this is the only 12-point bold font you have to have in your contract. I personally like to have it on the front page because a lot of owners obviously don't understand the whole you have to pay your deductible thing, and so by having it on the front page, you're addressing it, up front. This is the language that has been approved by the legislature. I just suggest you use this language. Now, I include a parenthetical TBCC effective, and that's just simply so that you can say, if you don't believe me, go look it up. And then I have the little insurance box in the corner. That's not required. That's just a Karen thing. But here's why I do that. Because the way the law is written, the contractor is required to collect the deductible, but the insured is not required to pay it. They're required under the policy. It's a unidirectional law, right? I was there when we were negotiating this thing, and we tried to get the insurance company to include a penalty for the insured for not paying their deductible, and insurance just wouldn't go there. So the only party who could be penalized for failure to follow this law is the contractor, and so there's that. But more importantly, an insured, this isn't an insurance claim. No, this is not an insurance claim. Why would you think it's an insurance claim just because the whole neighborhood's been hammered by hail? That's silly. So since the contractor is required to collect it, I want the insured to say yes or no, it's a hail claim, and then how much the deductible is. Because if they tell you the deductible is $1,500 and the deductible is $5,000, I don't want you in trouble for that. I want them in trouble for that. So I like to have them, ideally I like to have them fill out that little square. If not, they should be giving you the information so that if you're not collecting the full deductible, that isn't necessarily something that you're going to get penalized for. And by the way, I was having a conversation with one of the other attorneys in our office yesterday. She said she's seeing a lot more insurance companies asking for proof of payment of deductible. So there has been a lot of frustration over this law. And yes, sir.
I've got a question for you. So if the contractor is required to collect it and the homeowner is not willing to pay it, the contractor can settle at any point. I'll take something over nothing. But you can't do that ahead of time. You can't make a determination you're going to do that ahead of time. But I mean, in a situation, a contractor can still be liable if he's settling for,
the question is, what do you do when the insured refuses to pay their deductible? Well, you probably need to walk away from the contract. because you're creating a violation for yourself.
I've already contracted and completed the roof at the point that they start paying it, because we don't take payment for the deductible up front, we take it once the job is completed.
So if you're midway through the contract and the insured says, oh, you know what, I've just decided I'm not going to pay my deductible. It's like them not paying anything else, right? Any other part of the contract. You have an obligation to in good faith try to collect it. If they refuse to pay it, I would simply report that to the insurance company and say, look, I tried to collect it, here's my emails, and they're not paying it. Right? Yes, sir.
A question, what happens if, for example, let's say a homeowner is gonna replace the HVAC unit on the outside or something, and they don't wanna replace the cap on it, or the fence is already falling apart and they're thinking they're gonna replace it, and let's say that amounts for the total, they're just not ready to do it because it's gonna be $10,000, $20,000 to replace the whole thing, and they don't wanna replace that particular unit right at that moment. What happens if can you not do all the work and then still kinda collect the deductible? So the total amount is $20,000, just to throw a number, and the deductible is $3,500. And the amount that the insurance paid for certain items of the house that the homeowner don't wanna do right in that moment, how does that fall into this deductible situation?
Okay, so the question basically is, an owner doesn't want to do all the work necessarily. Can they use the unused ACV to help pay their deductible? Is that the question? So the answer is yes. The ACV money is the insured's to do with as whatever they want to do. If something is approved and the owner doesn't want to have the work done, you need to make sure in writing that you tell them insurance is only going to pay for this once. So if you think 2 years from now you're going to make another claim and they're going to pay for it and you're going to get it done then, I just need to let you know that's not the way this works. Then it's their decision to use their ACV money any way they want to. They can go to Disneyland, they can get new carpet, they can pay their deductible, they can do whatever they want. They can pay their deductible over time, they can pay it, on a payment plan, they can pay it through their ACV, whatever. Your job is to collect it. Their job is to figure out how they're going to pay it. And I know it's easy for me to stand up here and say that because I know it's a fight sometimes, but that's really the way it works. But anytime you're dealing with an insured and for any reason they don't want to do any part of the work, you need to make sure in writing, because if it's not in writing, it never happened, that you're putting them on notice that if they don't want that work done, they're not going to be able to get it done, via an insurance coverage later on. Does that answer your question? Yeah.
For your box that you like on the first page, do you have an initial spot for that so that they don't say, oh, you filled it in later?
Yeah, you can have them. Yeah, you could have them initial. You could fill it in and have them initial it. It's just another level of protection for the contractor. So, and obviously, at some point you're going to know what their deductible is because you're going to see what the insurance company approved. But every little thing that we can do to help to minimize your liability, that's my goal. Okay, so the most misunderstood by far issue related to residential contracts is the 3-day right to cancel. So let's talk about it. It only applies, to door knocking. It's not even door knocking. It's a personal solicitation initiated by the contractor anywhere other than the contractor's place of business. So if you're at a ballpark, if you're at the grocery store, if you stop to help somebody put gas in their car because they ran out, it doesn't matter. Anywhere other than your place of business where the contractor initiates the relationship. It only applies to residential. It does not apply to commercial. And for purposes of this law and several others, a rent house, even though it's a home somebody lives in, it's not being occupied by the owner, so it is not a homestead. It is not part of this deal. So rental property doesn't count. Commercial property doesn't count. It doesn't apply to emergency repairs, but don't take that then and do non-emergency repairs. And it never applies to commercial projects ever. So, in-person solicitation initiated by the contractor somewhere other than the contractor's place of business. If those things are happening, you are required by law to give a 3-day right to cancel.
So if somebody calls you out to inspect their roof, that 3-day rule doesn't apply?
Right, so if the insured reaches out to you, it does not apply. But you better make sure that you document they reached out to you. So if you have some mechanism, through your CRM where you notate that, or put a note in the file early on. Frankly, I like in the contract, if you don't want to have your 3-day right in all your contracts, then I like having a line in the contract that where the insured acknowledges that they initiated the relationship and not the contractor, and that is something I have them initial. And then at that point, they can't come back and say, oh no, really, well, here's the other thing. So the law says anyone who signs a contract is presumed to have read and understood the contract. So when somebody tells you, I know, and nobody reads them, right? But when somebody comes and says, well, I didn't understand that, and I didn't read it first, and you didn't, whatever, right? At the point where they sign it, unless they can show fraud or some sort of fraudulent inducement to sign the contract, they are bound to its terms. Now, if it's an 85-year-old retired person, that's going to be a little harder. But the average Joe, that's the rule. And I don't care if they read the contract. If they sign it without reading it, then that's unfortunate for them, but they're bound to its terms. So, but I do think if you don't want to have the 3-day right in all your contracts, you do need to confirm somehow how that relationship was initiated so they don't come back later and try to void the contract, which happens. Yes, sir?
How does that apply for the two-part service agreement to construction agreement?
So as for the service agreement, you would have it in the service agreement first because that's the initiation of the relationship. You would not need to have it in the contract.
In the construction contract?
Right. I see it.
Is there a different timeline for commercial?
So there is no 3-day right to cancel for commercial. That's it. There just is none. I see them in commercial contracts all the time. And here's the thing. If you give someone 3 days to cancel, then you have to honor that. So
There's no legal obligation to offer them only no cancellation?
correct. There's no legal obligation to offer a commercial property owner the right to cancel a contract. There's none. So, should you enforce them? I don't know. That's a question for another day, right? Because there's all kinds of reasons why you might want to. If you've put a bunch of work in and the claim was denied and, but for your efforts to document blah, 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 right? Legitimate. And anybody who wants to enforce these contracts, I have no problem with that at all. You've done the work. You were ready, willing, and able to do the work. You have the right to be paid. Yes, ma'am.
So that would not apply if there's already been an exchange of money. Let's say you did do an emergency repair first, and you billed them for it, and you exchanged. So the 3-day right is now gone.
So, that's a good question. And, you've already done an emergency repair. I mean, are you door knocking and randomly running across an emergency repair? Almost certainly never happens, right? Most emergency repairs, someone has called you because they have a problem and they're seeking a contractor. So I don't think it would apply anyway, but technically I think the law would say if you door knocked and you just so happened to catch them in the middle of an emergency, you would need to give them the 3-day right to cancel for anything beyond the emergency work. Yeah. Although I just can't imagine it happening. But yeah, if that were the case, I mean, honestly, if you just stopped by my house last October on a certain day, I had an emergency and I had sewage, spewing out of my upstairs bathroom. It was not good. And if you'd have knocked on my door and said, hey, I'm here to talk about a roof, I might have said, hey, I don't have a roof problem, but I certainly have a spewing problem. So it could happen, but I don't think that's the case. So here's why it matters. Because the contract can be voided at any time by the property owner who was entitled to the notice and didn't get it, even after the work is done. Yes, so I have gotten cancellation notices, after the work was done. And we're in litigation over payment.
Use them for paying.
Well, I think what the work was, the work was long, the work was done 6 months ago. Owner didn't want to pay. So, I send my demand letter, send my FDCPA if it's, whatever, and, send my demand letter, and hopefully we filed a lien on time, and blah, blah, blah. And so then we file suit, and then the insured hires an attorney, and the attorney sends me a contract cancellation notice, right? So if my client was obligated to give a 3-day notice and did not, that cancellation notice is effective, even after the work is done. Now the question is what's the obligation for payment? I believe that they're obligated to pay the reasonable value of the work. There's no contract anymore. So then when there's no contract, absent a statutory prohibition for collection such as you see with UPPA, then you get the reasonable value of your work. What you don't get is all the other stuff you had in your contract to protect you. So that's all gone. And you can get treble damages. So what damages has someone suffered if you didn't give them the 3-day notice? Maybe they would have gone with somebody cheaper. Now it's very speculative and that's hard to prove. But nonetheless, the downside is attorney's fees, court costs, and up to treble damages. So this is not a provision to take lightly. It's a pain in the butt. I know it is. We're going to talk about why it's really stupid. Some of the part of the rule of it is it's difficult to do right. Most people just don't do it right. But this is the result if you don't do it right. So I recommend you do it right. Okay. So it's 3 business days, not 3 calendar days. The notice is effective when it goes in the mail, even if you never receive it, which I just hate the mailbox rule, and this is one of the many reasons why I hate it. And the right to cancel cannot be waived. So that you can't put something in the contract saying, I knowingly waive my right to cancel, because you can't do it. So there's a 3-step, yes?
Can you require that they send it certified mail?
No, I don't think so, no. The legislature has created the simplest process possible for someone to cancel a contract. And so the 3-day, having to send it by certified mail, I don't think that's a requirement. So there's a 3-step process. First, the cancellation language, I'm going to show it to you in a second, has to be immediately adjacent to the signature block. That means right above, right below, right to the side. It has to be a minimum 10-point bold font. You have to tell the homeowner they have the right to cancel. And you have to provide paper copies of the cancellation form. Even if they sign, so they can sign the contract on your iPad or on their phone or whatever, right? But you have to give them 2 paper copies of the cancellation form. Why? Because the law was written in the 80s, maybe? Or maybe it's because the Texas legislature doesn't want, and by the way, there's a federal law that's very similar, but I believe it's because they don't want the person canceling to have to go have a printer or a scanner or whatever, right? So you give them the paper copies. All they have to come up with is an envelope and a stamp, which is now 61 cents for some unbelievable reason. And that's it. So if you don't do all 3 of these things, yes, ma'am?
So if they call and cancel via phone, it doesn't matter if they have to send that official?
So if somebody called and canceled by phone, I wouldn't want to have to stand in front of a judge and say, I knew they canceled, they called me by phone, but I decided that because they hadn't done it in writing, I didn't have to honor it. Right? So, yeah, yeah, right. Yeah, I think at that point, right. I mean, it's, right, they haven't complied. Yeah, but I think, and honestly, if somebody doesn't want me, I don't want them, right? I don't want to force someone to use me to do something and they're unhappy and it's just never going to go well. So, anyway.
Is this the one part that you would say, make sure you read to the client? You said, that it's their responsibility to read the contract, but it sounds like this one that you actually need to tell them.
So I would, if it was me and I was the one that was signing the client, I would point to the cancellation language and I would say, you have you have a 3-day right to cancel this contract. That's what it says right here. And here are your 2 pieces of paper. Now, that's how I would do it. I wouldn't, I mean, you can read it to them if you want to, but it's written, in, legislative language. It's, yes?
Do you have to have the whole 3-step process of like telling them and providing the paper copies if it's not a door knocking thing like they call it?
If it's not a door knock, you don't have to do this.
Okay.
But I recommend strongly that you document that it's not a door knock.
Okay.
But you don't have to. Okay. So here's kind of the rule, written down. The contract must include the date it was entered into, the name and address of the merchant, and the statement in the immediate proximity, right? So, yes, sir.
So if the statement has to be near where they sign, that means it's going to be in this statement is going to be in every contract that I have.
It's going to be in every contract you have, or you are going to have one contract for door knocks and one contract for not door knocks. So one of the issues some of my clients have is explaining to their salespeople when to use this contract versus when to use that contract. And so the simplest thing is just to have it in all your contracts, but if you don't want to, you just need to differentiate. Here's the folder for, the door knocking that you're doing while the build is going on. You're going to go talk to all the neighbors around, right? Hopefully. And then, here's the one, when it's a referral.
So, and what you're saying is this statement can't be modified at all to kind of clarify that this is null and void if you initiate a contract?
You could certainly put that at the end of this and then have them initial it. I would leave this language just like it is. I would not rewrite this. But if you want to put something at the end that says applies to door knocking only, the problem is I don't know that a insured or a consumer is necessarily going to have the legal acumen to differentiate whether that applies or not. Now, you can have your salespeople draw an X through it and write next to it, not a door knock, or NA or something, right? I mean, you can have your people exit out, right? I mean, there's different things that you can do if you don't want it to apply. Just, take a big red X, and then write, NA, not applicable. Yes, sir.
So would canvassing, if you leave a flyer or business card, would that be defined as a door knock?
Yeah, so canvassing is an interesting question, right? If you leave a flyer and then they reach back out to you. So the purpose of this law is so that people who are kind of interrupted in the middle of their life, right? And then just get all excited about something, right? And then they sign up for it. I've bought things that way before, but not for my home. So you're interrupting people and they get real excited and, oh boy, I'm going to get a, free roof or whatever, right? And then they're like, oh man, should I have done that? Should I have not done that? Should I get more bids? Should I, talk to my cousin who, thinks he's a contractor, right? And so that's the reason for the law, is so it gives people a cooling off period. I think if they get a flyer and they call you from the flyer, I think then it's not an in-person solicitation, it's a flyer. And they've reached out to you after an opportunity to evaluate if that's something they wanted to do. And I think in that case, it would not apply. I've never seen, I don't know that it's not out there. I've never seen any case law that's addressed that issue, but I do believe in that case it's not a door knock situation.
Same for a business card, if you just leave a business card?
Yeah, I think if you're just leaving something, you could put something into their Facebook, however that, things that pop up. Or you can just, leave something on their door. If they reach out to you, I don't believe it's a door knock. I believe that you have provided them literature and they have responded to the literature. I think it's completely different. Yes, sir, you had a question?
So we do electronic signatures for our contracts. Does that mean you have to print out the evidence too?
So electronic signatures are fine. If you want to have an enforceable electronic signature, just by the way, requires that you immediately provide a copy of the contract to the person who signed it. So the first thing is I have some clients who are using electronic services that don't auto-generate an email back with a copy of the completed contract. That's a problem. But whether it's signed in person or whether it's signed electronically, you have to give the consumer 2 pieces of paper, in paper. You can't email it. It has to be paper.
So the electronic signature, service emails them a copy, then it still doesn't matter, right?
Yeah, an email copy of a 3-day right to cancel is not compliant.
So we still have to print it out.
You have to keep in your truck or your car or, your motorcycle or whatever. You have to keep paper copies of the 3-day right to cancel. And that's why this law is so hard to really grasp, because it's just, it's the devil's in the details. Okay. You must provide a completed copy of the contract, by the way. So this is the notice to cancel. This is verbatim the notice to cancel. So down at the bottom there, you would put in your address, your name and your address, and then there are some dates that have to be filled out. So you're required by law to have 2 copies. I like to have a 3rd copy where the consumer acknowledges receipt of the notice. Because if they acknowledge receipt of the notice, then we know that we complied, and they can't come back and say, you never told me. So I like a third page for that reason. So my contracts are a 5-page contract, but 3 of them really are notice of cancellation. And again, not for commercial, and not for anyone who reaches out to you. Okay, so that was 3-day right to cancel. There are residential disclaimers that are required in contracts. Now, leaving out these disclaimers does not void the contract, but it does subject you to fines. So it's just, and actually both of them are helpful, so there's really no reason to leave them out. So this is residential only. This is the Chapter 27 Property Code warning. And this is the RCLA, if you're familiar with the Residential Construction Liability Act. That's what this is. And it basically says, if you don't like my work, you have to tell me about it and give me a chance to fix it. And if you don't, if by the way, if you are doing work for residential and you do get a complaint and they don't follow the RCLA requirements to give you an opportunity to inspect and to make an offer of settlement, then you don't have to pay for the repair. So that's a good thing. Minimum 10-point bold font. Anywhere in the contract, failure to include is a $500 penalty. And I've never had somebody actually solely make a demand for the penalty payment. But every time I'm in a lawsuit and I get a counterclaim, it almost always includes the failure to have the 27 warning in there, if in fact the 27 wasn't there. So that's the first one. This is out of Chapter 41 of the Property Code. And I have clients who take this out of their contract because they think it sounds mean, and kind of it does, but you have to have it in your contract. Don't take it out. Minimum 10-point bold font. It's a Deceptive Trade Practice Act not to have it in your contract. You can have up to 3 times damages. I don't really know what your damage would be for failure not to have it in there. It does not invalidate a lien if you leave either of these out, but they're to your benefit. And for compliance purposes, I just recommend you just put them in there. So now these only apply to residential. Okay, so let's talk about the optional stuff. I'm going to have to talk faster. Okay. So void or voidable. Your contract should never say void if insurance doesn't approve. Never. Never, never. Why? Because how many of you have ever had an insurance company deny the first claim, right? And they come back later and say, oh, well, we were wrong. It really is, this or that or whatever, right? So if your contract says that it's void at the point where insurance denies, you're done. So it's better to be voidable at the contractor's discretion, right? So here's some alternative language. I will save the drama and trauma of reading it. But I like to have, this contract can be, or this proposal can be withdrawn if not accepted within X number of days, partly because of material cost, but partly because just to kind of create a sense of urgency on the part of the buyer so that they want to, get the contract signed rather than just leaving it to be open. So the first one's a little tricky, right? It can be this proposal can be withdrawn if not accepted within 7 days, or in the event owner's insurance company declines sufficient coverage for owner's damage model made the subject of this contract. So that basically says I, the contractor, can say no and you cannot. So, and then the second one is a little more obvious. In the event insurance denies the claim, it's voidable at the option of the contractor. Because you don't want to have to do a job you can't do, right? So you need to be able to step away from a contract if the terms are not going to be something that you can live with. So then, after the right to cancel is passed, any termination, etc. So, which is we're going to talk about that. Okay, termination fees are absolutely recoverable if properly described. So I have heard a lot of things from a lot of people about termination fees. Don't call them liquidated damages. Liquidated damages has a very specific definition in the law. There's a two-part test. It's kind of complicated. It's not that interesting if you're not really litigating it, so I'll save you the details. But this is not a liquidated damage fee. This is a termination fee. Its purpose is to let the insured know that there is a cost associated with terminating the contract. You are entitled to your lost profits if you are the non-breaching party in a contract. So you're entitled to that whether or not you have a termination fee in the contract. It's not because of a termination fee. It's because by law, unless you waive that right, you have the right to be paid for your lost profits. What are your lost profits? That's after every single thing you would have paid had you done the job. That includes the sales commission. So a lot of my clients get tripped up on that because they do that before sales commission, and it's really after sales commission. It's what you, the company, would have made. That's what you're entitled to. So when you are putting in a termination fee, that termination fee cannot exceed what you would reasonably expect to make in profit on that job. So if your profit is, 25%, you can have a 25% termination fee. If you have a 50% termination fee and anticipated lost profits of 25%, that termination fee is unenforceable as a penalty. You would still be entitled to your lost profits, but you could not enforce the termination fee. So my termination fee says it's whatever the percentage is, right? And it's anything out of pocket that you've spent. So if you hired an engineer, if you had an Eagle View, or all the various things that you might pay money on, all of that is part of what you should have in your termination fee. Because I'll tell you, if you paid $2,500 to a consultant to come out and look at something and give you an opinion, that's not recoverable automatically unless you have it in here. Or you sue. That's part of your. That'd be something you would sue for as part of your lost profits. But you want to have that all in here. Yes, sir.
And how do you prove that? Like, for example, if we have, let's say.
So you know how much money you make on your jobs,
yeah,
right?
But how do you prove? Like, you just put a 40%, and where you would have to prove it is like a court or whatever.
So yeah, so. You guys know it's 30-30-40, it's 30-40-30, it's 40-30-30, right? Basically, depending on the materials or whatever. So typically, the profit that you split with your salesperson, however you split it, some of my clients pay it off the top, some of them pay as percentage of the profit. So it's anywhere from 30 to 50% is what you're going to split with your salesperson. So you're going to make anywhere from 15 to 25% on average on your jobs. So certain kind of jobs with certain kind of materials installed in a certain way, you have a pretty accurate estimate of what your profit is going to be day in and day out, right? That's how you make your money. You would have to prove your lost profit in court if you filed a lawsuit, right. And you would do that by saying, here's what I would have paid for materials, here's what I would have paid for labor, here's what I would have paid for equipment, here's what I would have paid for a permit. You just lay it all out there. And after that, what's left over is your profit.
But is that covers the profit of the salesperson and the company?
No, it's not the salesperson. Now, your salesperson could join you in the lawsuit and collect his commission or her commission, right? So I think you could do that but it would be a separate collectible, be a separate measure of damage. So yeah. Okay, UPPA disclaimer. I strongly, this is one of the maybe top 5 things I want you guys to take away from this today. The unlicensed practice of public adjusting. The insurance code 4102, I hate that law. I hate everything about it. I hate it, hate it, hate it. I don't like it. I would like it to go away. It's not going away anytime soon. So, in lieu of that, I want you guys not to get caught up in an accidental violation. So you may have some language in your contract that's just not quite right, and it might open you up to a claim that you were offering to be a public adjuster. You may have something on your website, and I've got disclaimers at the end of the presentation that we're going to talk about. So this disclaimer says, I, owner, acknowledge that contractor is not offering to public adjust or, advertising public adjusting services. So if you have an unfortunate little phrase somewhere in your contract, this can help save you from a UPPA claim. So I like to have it in the contract. And then here's some longer, more extravagant, I am not a public adjuster language that you guys can consider for your use. Material shortages, some clients tell me they have them, some clients tell me it doesn't matter. If you have a concern about materials, pricing, and especially if it's a long lead job, you may want to have something in your contract that addresses that. And here's some language that you can consider. Subject to management approval. I see contracts all the time that have this in here, so it's good and it's bad, right? If you have folks out there running amok and they're selling crazy stuff, and you want to make sure that before you take on the contract, you've approved it, that's great. What you need to understand is until you accept that contract formally, you don't actually have a contract. And that owner is not bound to honor the contract up until the time when it is accepted by management. So hopefully that makes sense. You want to make sure that if you have subject to management approval, that you are getting that approval done timely. So accept or reject. I like to do it in writing. Some of my contracts say, at the point where we're ordering materials, you can consider the management to have approved the contract, et cetera. But really, I like something sent back that says, we've accepted your contract and we're moving forward. Yes, ma'am.
How does that affect the 3-day right to cancel?
So
The contract hasn't started.
the 3-day right to cancel is a separate clock that's running from this clock.
Okay.
They could run at the same time. They could run, whatever. Yeah, they're completely separate. When performance standard controls, what performance standard controls your work? So I've seen all kinds of crazy things in contracts. So just if you're doing it, good and workmanlike, by the way, is like a C grade in high school. So it's what the average contractor would do. It's not a bad thing. Good and workmanlike sounds really great in contracts, and I like them, but just understand what standard, if you are if you're doing it per all, controlling governing authorities, that's a higher standard, perhaps, depending on the governing authority. So just know what it is that you're agreeing to, what standards you're agreeing to meet, and then just be sure that you're meeting it. So, and then I've seen, this is mostly in commercial contracts, subcontracts that I review. The other part of our practice is we represent commercial subcontractors, and they, these big giant GCs, and they have these 200-page contracts, which is just so wrong. And the part I have to read is like 35 pages, and that's just so wrong. But they have all kinds of standards, the highest standard possible, and if it's a choice between this standard and that standard, it's the strictest and all that stuff, right? So just know what it is and make sure that you're not promising to do something you can't do, because then you've created a breach when you didn't need to. Scope exclusions, nail pops, broken vases, damage to landscaping, driveways, walkways. You have no way of knowing whether there's any rebar or how thick the driveway is unless it's exposed somehow because it got washed out, right? You just don't. So be careful, obviously, when you're, dropping things on it, but we exclude that because that's outside your control. Yes, ma'am.
So if the roofer hits the gas line and it has to be repaired and it's $3,700, that's not our responsibility?
So
And
if,
the homeowner's gonna come to me and go, but you did it.
so, yeah, I had a lawsuit that lasted like 3.5 years over a pierced gas line. And we won, thank God, but anyway. So, yeah, definitely electrical from Freon, gas lines, et cetera, too close to the decking. So my contract says if you have anything too close to the decking, according to current standard, not 1950 standards when the house was built, it's not my fault.
So it's on the homeowner.
There's
So-
a plumbing code that you can reference to that.
Yeah, there's all kinds, yeah, there's all kinds of code. It's 3, you know, it's 3 inches, it's 5 inches, it's whatever, right? So your contract should exclude damage. Now, if you offer to inspect the attic, you're kind of opening yourself up for liability because you're kind of talking out of both sides of your mouth, right? So you just need to be really careful. Personally, if I had a client who called me and said, "Hey, you know, I know what the contract says because I wrote it, but you know, I hit a gas line and you know the owner wants me to fix it and it's $3,700." I'm going to say, "Well, you go fix it." Because for $3,700, do you really want to get in a big hairy fight with an owner? Maybe you split it, right? Maybe you something it, but that's not the kind of thing to have, for me, that's not the kind of thing you necessarily want to litigate. But if you want to say, hey, you know what? I'm sorry, but especially if it's something you could never see because it's in a part of the attic you can't get to, you know, you should exclude it, and then you can decide if you want to be, you know, a good guy or a good gal and cover it later.
Can I ask another part of that
Sure.
equation? What if it's the sub that hits it? So how does that, I guess it's your discretion if you make your sub pay for it.
Right. It would be your discretion. Maybe you and the sub split it. You know, it goes to, you know, is it something that you should have known that it was going to be a problem and you just did it anyway? I mean, most of the time that's not the case,
Right.
but that's just a judgment call. And, you know, it's client relations and it's subcontractor relations, and you're just going to have to decide, you know, how you want to handle that. Some of these things are much more difficult, and I'm sorry, that last bullet point, you can't see it, cosmetic issues. So the last bullet point says cosmetic issues. So I had a client one time called me and said that the homeowner walked out of their front door and unfortunately someone dropped a bundle of shingles on their head.
Oh, no.
Fortunately, the guy wasn't hurt. So the good news is it was funnier than it was tragic. Which I don't know, what does that say about me? I think it's funny, but anyway. That's keep people out of the work zone, right? And you can't really, if someone's home working or whatever they're doing, you can't really make them not come out their front door. I mean, you can try, right? But some things, you know, some people do get, you know, really seriously injured. Or, you know, I had a pet one time that unfortunately got out and got scared and, you know, drowned in a pool. And that's not something to laugh about. It was terrible. But those kind of things you really, you know, do want to make sure that you are excluding from your contract, because you just don't want to be responsible for that. That's and then I have some clients who say if the roof is open and there's a freak rainstorm, that's on you, that's not on me. Your homeowner's claim should cover that as part of the repair. I have other clients who say, you know what, I left too much open, so you know I'm going to take care of that. So I had a client one time who had a subcontractor who ran into some termite damage, and they kept pulling off decking to see where the termite damage ended. Well, it never ended, and so they pulled all the decking off, and then the rafters crumbled.
Oh, wow.
Right? That was not good at all, and there's no fixing that. It was really expensive and awful. And then, yes, sir.
So you mentioned not looking in the attic, like the contractor not looking in the attic. Like, did you suggest that, or like what?
So, yeah, don't say you're going to do an attic inspection unless you're going to do an attic inspection, right? If you're not going to do an attic inspection, say we don't inspect the attic. We are deck and above. Just be really clear. And whichever way you want to do it, I think it depends a lot on the type of materials, if you're, you know, et cetera, right? There's all kinds of reasons why you may want to look in the attic. There's reasons why you may not want to look in the attic. You need to have someone looking in the attic who knows what to look for, right? That may or may not be your salesperson because they're there to identify damage. They're not there to do a construction inspection. So there's all different ways to address that, and just, make sure that whoever's doing it is competent and that they know what they're looking for. And don't say you're doing ventilation inspections unless you're actually doing a ventilation inspection. Because when you do, if you're doing anything other than taking off and putting back on, you have taken ownership of having proper ventilation. If there is too much or too little, or it's in the wrong place or whatever, when you're done and something isn't working, you are now liable for it because you undertook that liability. So just be really careful about those kind of things. Okay, and then here's all the things that you're not providing. And we all know that nobody looks at their roof until they get a new roof, and then suddenly they're like, oh, it sags right there. And well, ma'am, that's your rafter, right? No, it's your roof. So, this is for that, right? You need an opportunity to cure. Part of that is under the RCLA if it's a residential. But the owner needs to tell you they have a problem and give you a reasonable opportunity to cure before they go out and hire someone else to do the work. Just make sure you have that in your contract. Change orders. My contract says I, contractor, have the right to perform change order on your verbal instruction, but I don't have to if I don't want to. Now, a text message is a legal writing that can be enforced in law. So if somebody sends you a text message and says, I want you to repaint my whole house and I will pay you everything that you want to charge me no matter how much it is, right? It could happen. It's not likely. It could happen, right? Whatever, right? I mean, if somebody sends you a text message and they want whatever, that is a legally enforceable document. The trick to a text message is you can't always see the date. And so if you're gonna take instructions via text, that's perfectly fine. Just make sure that you're capturing the date somewhere in there so that you can go back and say, you can see who sent it and you can see who it was sent to, but you can't see when. And so it's helpful to have that. By the way, if your phone has the ability to do so, turn off the whole getting rid of text messages. You should keep your text messages forever and ever and ever, because they are legally enforceable. And you don't necessarily know you're going to need that text for 2 or 3 or 5 years. So it's not expensive anymore to have things in the cloud. So I have 12 years of text messages on my phone. The right to supplement, it's best if you get that in writing. So here is some language. Let me see if I've got it in here. You need to, nope, I guess not. Sorry, I took that screen out. If anybody wants my language on the right to supplement, I'm happy to send it to you. Just let me know. Authorization to contact the adjuster, same thing. It's best to get that authorization in writing. And I like to make sure that I limit that to price, scope, and payment so that there's no question about whether I'm calling the adjuster to negotiate the claim. Overhead and profit, I know. That's a whole thing, right? So let me just suffice to say that make sure in your contract it says you're entitled to it. If you can get it, that's great. And then there's ways and means of doing that, and that's not the focus of today's presentation, but yes, sir.
Do you need to have an overhead and profit if you're using lump sum as opposed to cost plus?
So no, you wouldn't. Well, it depends on how you write your lump sum, whether you'd need the authority to get overhead and profit. And if you were doing supplements, you'd want to make sure your supplements were subject to overhead and profit. So no, technically, if you included it in there, you wouldn't really necessarily need it. But part of collecting overhead and profit is that the owner has agreed to pay it, right? Because then it's an incurred cost. And so having that in here, now if your contract says, I will take the RCV value of the claim, then you've pretty much neutered your incurred cost thing, right? But if the owner pays for it, or is obligated to pay for it, or has agreed to pay for it, then it's an incurred cost. It makes it a little easier to collect. That's why we have it in there. Payment terms. So this is one of the big things about commercial versus residential, because residential projects typically don't take that long. I like deductible paid immediately a materials draw collected the day before materials dropped, ideally, right? Because almost always, or the day materials are dropped and then the work starts the next day. If you don't pick up your materials draw before the work starts, you're just not going to get it because the homeowner's going to have a emergency, I can't be home to give you your check thing. So I like to collect it ahead of time. And then payment in full upon completion. And obviously insurance, has to issue the check, et cetera. But for me, and then supplements, as they're approved. So, I have 3 or 4 payments or whatever for residential. For commercial, likely it's going to be a longer job. You might charge by trade, you might charge by the month, you might charge twice a month. Whatever your agreement is on that commercial project, you need to have it in the contract. Because if it's not in the contract, it's going to have to be in a subsequently agreed document, like an addendum. So, anyway, that's that. And then substantial completion is a very important term for everyone to understand. Substantial completion means that the property is available to be used for its intended purpose. So it's not 100% final, but it's mostly punch sort of things that are left, right? Because if your contract says you're not entitled to be paid until final completion, that can be a problem because the owner may never accept your work and may say that it's never finally complete. So that's really important, and you need to keep that in mind. Payment should run from substantial completion tied to when insurance releases money. Warranties. So warranties are a thing that is often litigated. There's the material warranty and there's the labor warranty, and those are, there's 2 separate things, right? So the materials warranty is a pass-through, and your labor warranty is the warranty that you're going to be honoring yourself. So it should run from substantial and not final completion, payment in full as a condition to warranty obligations. So I'm a big fan of if you didn't pay your bill, you don't get a warranty. You don't get my warranty, and you don't get the material supplier's warranty. And I know that GAF will not issue a warranty if the contractor has not been paid. Depending on it probably depends on the sort of warranty. But yes, sir.
They'll issue it, but there's a clause at the very end. Excuse me, at the very end that says it's not valid unless the contractor is paid in full.
So so GAF will not honor a warranty if the contractor has not been paid in full. And I love that about GAF. Go GAF. That's great, right? Because owners want their warranties, and they need to pay if they want their warranties. So, but if that is, so I had a client tell me, well, everybody knows that's how it works. Well, no, yes, we all know that's how it works. But if it's not in the contract written that way, then you have to warrant the work even if you never get paid. So if you don't have a condition of payment and you get $0 and you have a 10-year warranty, you are warranting that job whether or not you get paid. Unless you want to have a big hairy fight and get out of it. So what voids the warranty, right? So if someone else is working on the roof, misuse, owner hasn't maintained the roof, caulking is not forever, new storms, whatever, right? So you just need to make sure that that's clear, and not just in the warranty, but in the contract, yes.
Do you recommend a separate warranty document?
Yeah, I recommend issuing a separate warranty document that's detailed, but you need to have this in your contract, because if it's not in your initial contract, you can't modify your original contract with a warranty document that's later issued. So this is where it needs to be. In the contract. Advertising, if you want to take pictures of someone else's home and use it for advertising, you need to get their permission. So, do you charge a restocking fee? Who keeps unused materials? How do you handle delays? HOA approval, that's not your job to get. Injury to the uninvited, we talked about that. I like the owner to agree to aid in collecting payment because it's their claim, and if they're not involved in payment, it's much more difficult to get. Okay, arbitration or litigation. I am a huge fan of arbitration. Now, if I'm representing the homeowner, I want to be in court. If I'm representing anybody else, I do not want to be in court. I want to be in arbitration. You get a subject matter expert who understands the issues and can make a decision based on the merits of the case and not based on who they like the best. If you want to require arbitration against a consumer, you have to have that in your contract in a minimum 10-point bold font. So you can have that as a provision. I strongly recommend that you have that as a provision, but it needs to be a minimum 10-point bold font. That's not true for commercial. You can just have it as any other kind of a term. Be careful of the arbitration provisions that say the contractor can decide in their sole discretion whether or not to arbitrate or litigate. I had a judge in Tarrant County tell me that was unenforceable. I disagreed, but he was the judge, so yeah. So there's that. So I'd be cautious of the one-way provisions. Just, you know, say you're going to arbitrate, or say you're going to litigate, or say if it's under, you know, $10,000 you're going to do this, and if it's over $10,000 you're going to whatever it's going to be, right? Just set those parameters out, but make sure that you have a minimum 10-point bold font if it's a homeowner contract. Arbitration, you're paying for your judge. It's expensive. It's not as expensive as 3 years of litigation, I guarantee it. But one arbitrator should be sufficient. Do you want to be able to conduct discovery? Arbitration does not automatically come with discovery. So there are various things that you need to consider. You want to make sure your contract, this is maybe thing 3 or 4, make sure that your contract waives consequential and exemplary damages. So a direct damage is there's the leak in the roof and the drywall and the flooring is damaged and has to be replaced. That's a direct damage. A consequential damage is there's a leak in the roof, it leaked onto the guy's computer, he missed a $2 million deal, and now he's suing you for $2 million. Right? That you don't want. You just don't want it. Exemplary damages are penalty damages. It's to make an example of someone. Some can be waived, some cannot be waived, but you certainly want to get as many waived as possible, and so you want to make sure that you are waiving consequential and exemplary damages. Attorney's fees. In Texas, on a breach of contract, you're entitled to your attorney's fees by law. But it's too easy to have that in the contract, not to just have it in the contract. It makes it much easier to enforce if it's there. Interest, the default is 6%. The maximum you can charge is 18%. That's per year, not per month. So you might as well have the maximum available interest in your contracts. And then you need to say when it starts, because if you don't, there's really funky rules that decide when it starts. So it should start 30 days after the bill's due, 10 days after the bill's due, whatever the case may be, right? You cannot charge 2% or 5% per month for late fees. You can't do it. That's a usurious claim, and it opens you up to all kinds of liability, and you just can't do it. So just 6%, 18%, anything in between. But have it in the contract. If you don't have it in the contract, you're going to get 6%. If you want more than 6%, just state it in the contract. Annually. It's simple interest. Here's the other thing. So it's simple interest. That means if you charge 18% per year, you're getting 1.5% per month. You do not charge interest on top of the interest. That's the difference between simple interest and compound interest. So your interest charge the first month of the year is going to be the same interest charged as the last month of the year, because you're not charging interest on interest. Liens for non-payment. So that's a whole nother subject, but you should be filing liens on your unpaid work. If it's residential, the deadline to file the lien is the 15th day of the third month following your last work. So if you did work today, your deadline to file a lien would be May, June, July 15th. If your last day of work was April 30th, your deadline to file a lien would be July 15th. It's the 15th day of the third month. If it's commercial, it's the 15th day of the fourth month. You get an extra month. Yes, sir.
So that's including giving the letters with intent to file the lien.
If you have a direct contractual relationship with the owner, you do not need to give them any letters. You just have to file the lien on time.
One other question.
Yes, sir.
This is something I've heard recently. On a residential claim, do both parties have to be on?
The husband and the wife. So if it's two cousins, if it's a husband and a wife, if it's a mom and a daughter, whatever it is, right? Everybody who is a title owner on the property has to sign the contract before the work starts. They don't have to sign it at the same time. They both have to sign it. Typically, it's a husband and wife. They both have to sign. If you only get one signature and not two, and by the way, common law, this is a community property state, so the wife does not have to be on the title in order to have a community property interest and be a signer on the contract. So, ma'am, sir, are you married? So I need to have your, right, just ask, because you won't necessarily know. Now you can go on the Central Appraisal District and you can look up and see who signed the contract, right? It might be a trust. It might be, there's all kinds of different, right? It's best for you before you start work that you confirm that and you have that entity sign the contract. But if it's a husband and a wife, they both have to sign. If you only get one signature, you cannot file a lien, but the person who signs still owes you the money. So you can still file for breach of contract, quantum merit, blah, 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 right? All that stuff. But you can't file a lien unless both, all parties who own, now in California, people get together and things are so expensive there that, you could have half a dozen people on title and they would all need to sign if it was Texas, right? But typically it's husband and wife. Yes, sir.
Are the lien standards, rules, same statewide or county to county?
Nope, it's statewide. That is the Texas Property Code subchapter. It's chapter 53. I think it's subchapter K, maybe. It's 256, like 53, 256, that area. Yeah, the husband and the wife both have to sign before the work starts. Not at the same time, but before the work starts. You have to record the contract in the county. You don't have to do it before the work starts, but at some point prior to, getting a judgment. So there's various rules, the most important of which are address on the contract, husband and wife both sign before the work starts, 15th day, 3rd month, whether or not the insurance company has released money. So the Texas Property Code doesn't care whether the insurance company released the money. That's not what triggers the obligation to pay or the deadline to file suit. It runs from when the work is performed, not when you bill it, not when it's paid for, yes.
Karen, what if one of the homeowners signed, right, but there was no price on it because insurance?
It doesn't matter if there's no price.
Okay, it's still enforceable.
So what makes a contingency contract enforceable is not, so it says, the contingency contract says, I'm going to do the work insurance approves for the RCV value of the claim, basically, right? So even though we don't know what insurance scope is going to be approved, and we don't know how much it's going to be, we have agreed on how those terms are going to be defined, and therefore that's what makes it enforceable. But if only one of them signs it, they're the only ones that are obligated to pay.
What if no work has been done, just going to the insurance company?
What regarding what?
If a homeowner signed a contingency, right?
Yeah.
But we haven't started on the roof.
Right.
We attended the insurance meeting, is that still enforceable?
Sure.
Okay.
You don't have to do work for the contract to be enforceable. As long as you were willing to do the work, able to do the work, you don't have to actually have done work. So,
Does
okay.
that still apply for the subcontractors? Because they have no idea if they want to put a lien on that.
Subcontractors have to give notice to the owner before they file their lien.
But
So if you don't have contractual privity, you have to give notice to the owner before you file a lien. If it's residential, you have to give notice by the 15th day of the 2nd month. They're rolling month-to-month notices. So it's so ridiculous, honest to God, it just slays me, but it's a rolling month-to-month notice. So for every month you're not paid, if you're working on residential as a subcontractor, that means you're doing work for someone, a general contractor who's contracted with, right, the owner. 15th day, 2nd month, for every month of unpaid work. If it's on commercial, it's the 15th day of the 3rd month for every month it's unpaid.
But it's the same thing if both of them haven't signed, like subcontractors?
Well, right, and so it doesn't matter on commercial or rent houses, it doesn't matter who signed it, right? If you have an authorized signator, then you're good. It only matters on residential, but yeah, if the general contractor doesn't follow the rules, then the subcontractor cannot file a lien. That's true, absolutely. There's something called a constitutional lien. It's magical. There's a 4-year deadline, and there's no notice requirement. You just have it because you did work. It only applies to commercial. There is actually the Constitution has a section in, it's 1650 anyway. But one of the requirements is that the contract be signed in an attorney's office, a title company's office, or the mortgage company. And that's not the kind of work we do here. So you could, if you wanted to go to the trouble, I've often thought about making a virtual office that people could go into and sign contracts, but anyway, it doesn't work for residential, but it works great for commercial. So if you've missed your deadline on a commercial project or on a rent house, don't despair. You can assert a constitutional lien. Contractual liens, they're good for some things that they're not going to trump the residential requirements to be followed, but they're not bad to have. So, okay, disclaimers. I got these from John Hotelling, who is an attorney in Louisiana, and I rewrote them because they were long, and mine are still long, but they're shorter, but I have his permission to use them. So this is, oh, sorry, I got this out of order. Yeah, so this is the language that entitles you to an enforceable lien against the insurance proceeds and the contract. I don't know how enforceable it is, but it's not a bad thing to have in the contract. Okay, so here's the email disclaimer. So these disclaimers are specifically for the purpose of avoiding a UPPA violation. That's it. So what they basically say is, everything I'm telling you, in whatever form I'm telling you, I'm not intending to violate the public adjusting law. If you think I have, let me know, because that was not my intention, and you can talk to my attorney about it. So here's one for email. Here's one for your website. So most of you probably have your websites written by third parties who may or may not even be in the state of Texas or know what the laws are. I've seen some crazy, crazy things on websites. This will help you avoid a UPPA violation. Just stick it on the bottom crawler part of your website, and it just says, anything you may read to the contrary, we're not offering to or providing public adjusting services. And then this goes on the bottom of your Xactimate, and this does several things, one of which is turns your Xactimate into a lump sum contract so the adjuster can't go pick through it line by line. And it says, again, we're not violating the Public Adjusting Act, and we're serious about our estimates. So, American Policyholders Association is an organization that is created to address insurance company fraud. So, if you have any interest in joining, you can look them up. It's a great association. I've been a member for a long, long time, and they're doing some good work. And it's worth your consideration. And that's it. Questions? Okay, you did good. Thank you.
Thank you, Karen.